And it's not so frequent they say that they follow the merit. And that's, I think, I'm sorry, because it should be used more to give proper messages to the parties. So this is more or less the practice. But again, sometimes we also saw a request for interim award on advance on cost, but this is a little bit more complicated issue that maybe it's not the right time of the day to discuss, but that's something we saw. Thank you for the microphone.
Ok. Alors, en ce qui nous concerne, on est guidé par un principe que nous considérons comme essentiel, c'est l'équité. Et à partir de là, et aussi, un deuxième critère qui est très important, c'est la bonne foi de la partie perdante. On le prend en considération exactement. Et bien entendu, lorsque nous avons déterminé les frais, et notamment les coûts finaux, nous sommes toujours dans la philosophie de ne pas faire trop supporter à la partie qui a perdu la totalité des frais. Donc c'est pour ça déjà, lorsqu'on a supprimé les frais d'avocat, ça soulage la partie qui a succombé à l'arbitrage. Comme je l'ai expliqué, il y a certaines entreprises, des fois, qui sont dans des difficultés financières très aléatoires. Alors qu'est-ce qu'on fait? C'est pour ça que nous avons cette politique jusqu'à présent pour, comme je l'ai dit précédemment, pour sensibiliser les gens à l'arbitrage. Mais quand même, nous avons une pratique. Lorsque nous avons, avant de rendre la sentence, nous faisons supporter les frais aux parties. Pourquoi? Ils ont été calculés préalablement. Pourquoi? Parce que si la partie qui vient retirer la sentence n'a pas payé, le centre ne sera pas payé. Alors, ce qu'on fait, la sentence... Alors, bien entendu, jusqu'à présent, on n'a pas rencontré de problème par rapport aux sentences finales. Pourquoi? Parce que les deux parties ont payé, et ce qui ne nous a pas engendré des problèmes. Mais par contre, les problèmes, on a certains arbitrages en cours où on est sûr que nous aurons des problèmes, et à ce moment-là, malheureusement, la partie qui aura gagné, elle devra supporter, si vous voulez, l'ensemble des coûts. Et s'il y a manifestement également une mauvaise foi de la partie, il se peut qu'on fasse supporter à cette partie l'ensemble des coûts. Mais la politique actuelle, c'est de partager les coûts tant qu'on peut le faire. Mais bien entendu, le principal est dû, ça, on n'y revient pas. Merci, Monsieur le Président.
Thank you very much. Mohamed, what about in Egypt regarding allocation of cost?
Allow me, Professor, before telling you or giving you an idea about the allocation of costs, to tell you the following. We have two particular means in order to control costs. First is that we may review. We have a provision that allows the institution to review the costs by decreasing them. And we have a cap of 25%. This was introduced in 2011, and it was applied once when we deemed it fit that this case does not deserve such amount either of admin fees, the fees paid to the institution, or the arbitrator's fees. They can also be increased, and the cap is also 25%. Another means, and here we are slightly different than in Milano, is that we don't, the default rule is that payment of arbitrator's fees is paid upon rendering the final award. Exceptionally, you can take up to 50% of arbitrator's fees after the final hearing of the case. But the rule is that you get paid when you render and you deliver the final award, and we believe that this is extremely important to control costs, especially to avoid what you all know is well known as strategic resignations, successful challenges. So if you pay fees and the arbitrator resigns, you have a problem here. and costs could be increased because you would be asking for additional arbitrators' fees. Regarding the allocation of costs, we have a default rule. The principle is that costs would follow the event, like in most of the, this is a well-known principle in arbitration, so the costs would be borne by the unsuccessful party. However, as you know, the arbitral tribunal has the discretion to decide otherwise. Thank you very much.
Thank you. Yes.
The same exactly as in Egypt. It's up to the tribunal, arbitral tribunal, to allocate the cost among the parties. We don't have any role to discuss this with the panel. Maybe 50-50, 75-25, 70-30. It's up at the discretion of the panel of the arbitral tribunal to allocate the cost. But we fix the cost at the end, according to the panel that we have, according to the tableau.
Senem, what about allocation of costs?
Yes, both in Turkish international arbitration law and the Code of Civil Procedure provide that unless other...
Yeah.
Both international arbitration law and Code of Civil Procedure provide that unless otherwise agreed by the parties, the arbitration costs shall be borne by the losing party. But if there is no clear-cut winner, I mean, if they win partially, then the arbitration costs shall be shared between the parties in accordance to the extent they prevailed, to the proportion they win. So this is our provision according to Turkish law.
Thank you, Senem. Now, the last question. Before 4, do you have emergency arbitrator proceedings in Milano? And what about the costs or expenses?
No, we don't. We don't have.
You don't have. In Algeria?
Oui, si elle est demandée, bien entendu, par une des parties, nous le faisons. Parce qu'en principe, dans notre règlement, il y a l'arbitre unique. Si les parties sont d'accord pour un arbitre unique, il n'y a pas de problème, mais il peut y avoir une demande de référé arbitral, et à ce moment-là, bien entendu, on donne suite à cette demande.
Okay, merci. Emergency arbitration.
No, we don't have, and since this would be my last chance to talk, I would like you to ask our colleagues whether they have seen third-party funding under the...
Yeah, this is also
Thank you.
important. Yeah, okay.
We don't have emergency arbitration.
We don't have.
We don't have, yeah, okay. Yeah, party funding.
Je voudrais ajouter quelque chose. Actuellement, l'arbitrage en Algérie est concurrencé par la justice étatique. Je m'explique. Une nouvelle loi est sortie où les affaires commerciales doivent être jugées au niveau du tribunal en moins de 3 mois et à la cour en moins de 6 mois. C'est-à-dire qu'une affaire commerciale peut être traitée, exécutée pratiquement en 9-10 mois. Ça fait que les gens se disent pourquoi on va à l'arbitrage? Parce qu'en principe, on a rendu que l'arbitrage, c'est quelque chose de rapide, etc. Donc, on est concurrencé par cet aspect. Mais nous luttons contre cette idée en disant que le juge est juge unique au niveau du tribunal. Donc des fois, ces sentences ne sont pas fiables. Et la contre-attaque du centre, c'est de dire qu'il vaut mieux être jugé par 3 experts, 3 arbitres qui ont un très haut niveau pour pouvoir avoir la meilleure solution possible. Mais c'est un élément important à prendre en considération. Merci, Monsieur le Président.
No, so far we never experienced third-party funding. It's quite a new subject, great interest, many debates also in Italy started, but so far no request. Okay. To the best of my knowledge. Then if a party is funded by someone behind the scene, then I don't know.
Here? No.
to the best of our knowledge also, we have not seen that.
The same.
No, we don't have the same. Exactly.
The same.
The same. Okay. Thank you. Now, do you have some questions, concrete questions? Okay. please identify yourself and please, to whom would you like to direct your question?
Well, Paolo Mazzolini from Geneva. I would like to address my question to all the panelists, if possible. I think I know the answer from Milan, but I was wondering whether it is possible for the parties to opt out from the system that you described in order to allocate and handle legal costs and fees and expenses. Thank you.
The answer from Milano is no. If the parties want to apply the Milan rules, derogating from the Milan system of schedule of fees, cost, expenses, we do not administer the case. They are free to take the arbitration proceedings out of the institutional environment and turn into an ad hoc arbitration proceedings. They do. It's one of the very few rules that we do not, that cannot be waived by the parties. This one is one, the other one is impartiality and independence of arbitrators' control. All the rest can be derogated, but not cost. It would be quite easy to say, let's go to Milano, let's use the rules, but let's make 30% of the fees. That would be, for us, unacceptable. And then we do not admit any direct relationship from the economic point of view between a party and an arbitrator. That's something, it's a principle.
Okay, thank you. What about your...
Well, this is an excellent question. As in Milano, you cannot opt out when it is related to arbitration costs. However, we have certain provisions that gives the parties the possibility of opting out and modifying certain provisions. Maybe a related question is whether you can opt in. But in an ad hoc arbitration, you can opt in by selecting only the chapter on costs. An interesting incident that we have met in Cairo some 2 years ago, an arbitrator accepted to sit, provided that we apply the average fees, arbitrators' fees, instead of the minimum that we have deemed it fit to apply. For us, whether you call it opt-out or opt-in, this was not acceptable to the institution. It was a conditional acceptance of his mission that means a rejection of his arbitral mission. Thank you.
What about?
We don't have such a practice. Never.
We don't have also any provisions which allow for the opt-out.
Okay. Any question? No. Then I would like to thank all panelists and also the audience. It is a very useful and fruitful debate. Now I am putting an end of the panel, and I invite Mr. Giarosson for concluding remarks. After you, Mr. Azzali would make the final words, would say final words for the greetings. Oh, yeah, okay, good, thank you. Mr. Giarosson, please here.
I have two jobs. The first one is to draw a conclusion, not a synthesis, but a conclusion of our reports and debates. And second, in a few words, I will have the pleasure to present the East Promed project. As the official languages of ISPRAMED are French and English. I will do my presentation in French, and I will do in English the conclusions. It's a way to balance the work for the translators. Let's begin by the very beginning. What does the word costs mean? The answer was given this morning by Professor Ozune. Costs are, as a whole, arbitration fees and arbitrators, various expenses, experts' fees and expenses, administrative fees of the arbitration center. And one must add the legal expenses of the parties, it is the council's fees. Why do we meet today to address this topic? I will revert to Mr. Nabil Koka's quotation from Philippe Fouchard. Arbitration is an apparently rudimentary method of settlement of disputes, since it consists in submitting them to ordinary individuals whose only qualification is that of being chosen by the parties. Arbitration is only apparently rudimentary because in the real life, the arbitrators are no more ordinary individuals, but high specialized lawyers, and so are the councils. Then one immediately faces a difficulty. How, at the same time, can it be possible to attract many parties to arbitration and high-level lawyers as arbitrators? These are two objectives. These two objectives are, of course, very difficult to reconcile. Everybody here agrees on the fact that arbitration is expensive. I didn't hear the contrary today. Whose fault is it? One of the sponsors, after one of our speakers, reminded the ICC survey that showed that in international arbitration, 82% of the fees, the costs are represented by council's fees, 2% for the administration, the arbitration center, and 16% for the arbitrator. Queen Mary's survey, also quoted twice, led to the conclusion that it's not really the council's fault. Maybe I'm naive, and I will not go further in this debate, but I will just notice that the great majority of the answers of the Queen Mary's survey came from councils. Who must be blamed? I share Stefano Azzali's view. Everybody. But be aware that everybody does not mean nobody. Of course, we were not here today to blame anybody, but to find solutions to prevent arbitration from becoming too expensive. My feeling is that each actor in the arbitration field is partly responsible and must act in order to save costs. But how? We heard today some recipes. I will remind you some of them, and perhaps add some more. The main question is how to be a cost killer in arbitration. The first two cost killers could be the parties themselves. Some costs can be moderated by adapted provisions in the arbitration clause. As a matter of fact, part of the remedies are in the parties' hands when they draft the arbitration clause. One or three arbitrators. Parties could foresee that if and when a dispute arises, they will in good faith decide if they will have one or three arbitrators. Some institutional rules let the arbitration center decide the number of arbitrators if it has not been provided for in the arbitration clause. Parties' behavior is an important element. As a matter of fact, as Professor Ozunay told us, the arbitrator has a great power to decide which party will bear part of all costs. One of the elements taken into account is the behavior of a party. For this reason, the loser is not necessarily the one who will bear all the costs. When the arbitration starts, the claimant can save money, as Stefano Azzali reminds us, when it gives the amount of its claim. If he exaggerates, it will cost him more because the advance asked by the center will be more important. The choice of the place of arbitration can be an important source of expenses, especially if it is situated very far from the party's place. But the element that must be taken into account is not necessarily the number of kilometers, but can be too the choice of a country which is arbitration friendly, that can easily and quickly help the arbitration to proceed. The topic of the place of arbitration leads me to the role of the arbitrator. As a matter of fact, the arbitrator can play an important role in order to save costs. The seat of arbitration chosen by the parties or fixed by the arbitral institution may be different than the very place where the meetings or hearings will take place. The arbitrator may, at the beginning of the arbitration, recommend the use of conference calls or other systems. The arbitrators have in their hands tools for saving costs. They can reduce the timetable, for example. Arbitration centers can't do a lot about counsel's fees, which are not under their control, of course, but they can act as far as their own fees or those of the arbitrators are concerned. Moreover, they can adapt their rules to small claims, and more broadly speaking, they have to find how, in their rules or in their practice, they can reduce costs. Each arbitration center, and we just heard about that, has its own rules and practices that can shorten the time of arbitration and so the costs. I will not come back to what has just been said by the different representatives of 5 different centers, which are all members of ISPRAMED. As time is money, the centers should have an eye on the schedule, especially on the time taken by the arbitrators for rendering the award after the last hearing or after the post-hearing briefs. Some of the arbitration rules have set up a system of time limit that they do not systematically extend, but they extend only after having asked the arbitrators for the time they really need, and they can insist on the necessity to hurry the proceedings. The ancestral rules contain different elements that can focus on the very goal of saving costs, as Mr. Soriel told, when he addressed us some of the provisions of the ancestral arbitration rules, namely, if I remind, Article 41. Sometimes, and it is what Professor Edem explained, the state, the lawmaker, can interfere. And he took especially the example of domestic arbitration. Turkish law provides for scales of costs based on the monetary value of the claims, so parties know in advance where they are going. And of course, international arbitration is more expensive than the domestic one. During the arbitration proceedings, arbitrators and/or arbitral institutions have a role to play. Here again, I do not think that there is a sole way to save costs, but a lot of different ones. As for the expenses, and from a material point of view, the parties can save money by, for example, hosting one after another the hearings in their own offices. if it's technically possible. Now, turning to more juridical issues, parties and arbitrators, when drafting the terms of reference, could avoid too complicated procedures, and I particularly think to those procedures in which parties add civil law country system, wide exchange of briefs, and common law system, discovery, extensive examination and cross-examination, and then post-hearing briefs. If the written briefs are extensive, it's useless to have long hearings where a lawyer reads for hours documents that have been already read by everybody. In my opinion, except for important cases, it's counterproductive to systematically propose to the parties a separate timetable for the disclosure of the documents. This often creates useless debates, and the special schedule organized for that is quite long and time-consuming. These are some examples among many others. And finally, we don't have to forget the importance of legal culture. In a word, there is no magic recipe, but each person who intervenes in an arbitration has in its hands part of the solution. Without any transition, the transition is change of language. En français maintenant, qui est une langue que j'aime bien, je vais vous dire quelques mots de l'ISPRAMED. L'ISPRAMED, cela veut dire Institut pour la promotion de l'arbitrage en Méditerranée. L'ISPRAMED est un animal original. Il ne s'agit pas d'un centre d'arbitrage de plus, c'est en fait un réseau, network, composé de centres qui existent déjà, qui restent indépendants, mais qui mettent en commun leur expérience de manière à agir ensemble dans le but de promouvoir l'arbitrage dans le monde méditerranéen. Il y a beaucoup de litiges internationaux qui ne se retrouvent pas devant des arbitres alors que les parties auraient tout intérêt à choisir l'arbitrage. Ces litiges qui ne se retrouvent pas devant des arbitres, c'est parce que soit l'arbitrage est trop cher, et on a donc le lien ici avec notre thème d'aujourd'hui, soit parce que ces parties, je pense spécialement aux moyennes entreprises ou aux entreprises qui, sans être de grandes entreprises, ont quand même une activité internationale. Et elles n'ont pas forcément entendu parler d'arbitrage. Ces parties, même si elles entendent parler d'arbitrage, même si leurs conseils savent ce que c'est, seront reluctant, réticents, parce qu'ils auront peur de franchir le pas et d'aller confier leur arbitrage à une institution d'arbitrage qui pourrait être trop chère ou qui pourrait être trop éloignée de chez elles. Il faut faire connaître l'arbitrage aux moyennes entreprises qui commercent dans le monde méditerranéen. Et l'expérience montre que trop souvent, les centres qui existent vivent en vase clos et ont du mal à se faire connaître à l'étranger ou bien à se faire accepter par la partie étrangère qui ne veut pas, dans la clause, renvoyer à ce centre d'arbitrage. Et c'est là que l'ISPRAMED, à mon avis, peut montrer tout son intérêt. En effet, tous les centres qui participent à ISPRAMED, et il y en a 5 de représentés ici, il y en a encore 2 autres qui n'ont pas pu être des nôtres, le centre tunisien et marocain qui ne sont pas représentés aujourd'hui. Tous ces centres partagent le souhait de développer l'arbitrage en travaillant ensemble, non pas pour distribuer les arbitrages existants, non pas pour se les distribuer, mais pour permettre par des conférences, par des rapprochements entre leurs règlements, de faire savoir que tous partagent et appliquent quelques règles fondamentales communes sur, par exemple, l'indépendance et l'impartialité des arbitres, sur les conditions de leur nomination et de leur récusation, sur les coûts de l'arbitrage, sur des questions déontologiques, Il s'agit de montrer par cette appartenance commune que ces centres présentent des garanties, qu'ils peuvent être dignes de confiance pour une entreprise étrangère, qu'ils permettent d'organiser des arbitrages dans le monde méditerranéen sans aller chercher pour de petits litiges une institution qui serait beaucoup plus loin. Et lorsque l'on vient arbitrer auprès d'une chambre depuis l'étranger, cela favorise aussi, par la renommée que cela donne à ce centre, ça favorise par un effet retour l'arbitrage domestique. Les membres d'ISPRAMED réfléchissent à organiser au sein de leur conseil d'administration, de leurs boards, des participations croisées. C'est ce que fait, et nous sommes quelques-uns ici à l'avoir expérimenté, c'est ce que fait depuis des années la Chambre arbitrale de Milan. Je crois que c'est une excellente idée parce que cela permet d'avoir des étrangers qui sont capables de voir comment, enfin qui sont en situation de voir comment fonctionne ce centre et de retour dans leur pays, quand ils sont interrogés, ils sont capables de dire que c'est une institution sérieuse, qu'il y a d'ailleurs beaucoup d'arbitrages qui sont organisés, et je ne dis pas ça pour faire plaisir à Stefano Azzali, mais parce que c'est vrai, la Chambre arbitrale de Milan organise chaque année beaucoup plus d'arbitrages que les 5 ou 6 ou même peut-être 10 institutions françaises que je connais et qui ont chacune quelques arbitrages, mais moins. Et finalement, il vaut bien mieux avoir un seul centre qui est très ouvert, y compris à l'étranger, et qui finalement démontre par ses résultats qu'elle a eu raison d'opérer ce choix. Ce que la Chambre de Milan a su faire pour promouvoir l'arbitrage et le développer, les membres d'ISPRAMED pourront aussi le faire, que ce soit à Casablanca, au Caire, à Beyrouth, à Alger, à Tunis, à Istanbul bien sûr, et puis aussi à Milan. Cet arbitrage qui est voulu par les membres d'ISPRAMED est adapté à des litiges qui sont soit importants, soit moins importants, même modestes, qui opposent des parties qui partagent un droit, un système de droit dont les racines sont communes, le système romano-germanique, le droit continental si vous voulez. Cet aspect relatif à la culture commune dans laquelle baigne tout le projet ISPRAMED me paraît très important. Et c'est sur ce retour aux sources et ce point commun que je souhaitais terminer. Je vous remercie pour votre attention.
Thank you, Charles. I think there is really very little to say. Don't worry, I will not take more than a minute. The reason why we decided 1 year ago, more or less, to discuss about cost within our network was exactly for the reasons that Charles has mentioned, that we believe that maybe altogether we can do something on this issue. We also believe there is no magic formula, as we all agreed, on controlling cost, but maybe through institutional arbitration, especially if offer according to, let's say, common principles, international standards, no matter whether in Istanbul, in Milano, in Algeria, or one of the centers of the network, might lead to less expensive arbitration. So this is just to explain, and I wish to thank, of course, ITO, the Chamber of Commerce of Istanbul, for the hospitality, UNCITRAL for the support, and of course the concrete support of the 5 sponsors that they made this event possible. Then, if you don't mind, I would like to thank Lorena, that angel there. You don't see the wings, but she has 2 wings. She's an angel. And of course, Senem and Ipek Aktas, that I don't see her around, but just to thank them. And next meeting, we don't know. Last year we met in Cairo for the similar meeting. Next year we are discussing whether to go to Lebanon or to Algeria or to Casablanca, but of course we will let you know. And thank you for being with us today, and have a nice evening. Thank you.